Hello, everyone, and welcome to episode 7 of Adventures in Security, Encryption, Angst. The battle between the government and Apple is just one more phase of the privacy versus security war. At least it'll be a war until government and privacy advocates can arrive at a middle ground that provides reasonable and appropriate levels of both privacy and security. In this video, we explore the different positions taken by privacy and security advocates, how current laws apply, and steps government is taking to start the discussion. Before we dive in, let's make sure we're all defining terms in the same way. Privacy keeps our information safe from anyone we don't want to see it, including the government. This requires controls like authentication and encryption to lock out the unauthorized. Security in the context of this discussion does not involve confidentiality, integrity, and availability. Instead, it involves protecting the citizens of our country from crime, terrorism, and other threats that cause harm. So where does that leave encryption in this discussion? We encrypt information for two reasons: to ensure integrity and to ensure only authorized people can see it. Allowing only authorized access falls under the heading of privacy. It is really the only tool we have to keep everyone out: criminals, terrorists, competitors, and governments. We begin our discussion with a look at why government, particularly law enforcement, requires access to your encrypted information. The main points in their arguments always come back to the same desired outcomes. The first is preventing terrorist attacks. Terrorists use encrypted communication to plan and execute attacks. They also store, on encrypted drives and phones, information that can prevent future attacks. Other evidence requirements include investigating crime. Many criminals today are tech-savvy. They use the same or similar encryption tools to hide evidence. To achieve these law enforcement security outcomes, federal, state, and local agencies believe they need the ability to access any data, anywhere, on any device. When they can't crack the encryption password, and no, you don't crack the encryption program, unlike some books and movies would have you believe, they try to force the suspect to give them the password, or they file for court orders requiring tech vendors to crack it for them. Recent attempts include the FBI securing a court order to force Apple to crack the San Bernardino iPhone, and the introduction of the Compliance with Court Orders Act of 2016. The Compliance Act would force people and tech companies to comply with court orders like the one Apple is resisting. It appears this foray of Congress into something they know little about will never pass. This is fortunate because there are people in government who understand how these challenges must be addressed, and one of the most prominent is Secretary of Defense Ash Carter. Carter commented during an interview at the RSA 2016 conference about the differences facing proponents of privacy and security. His solution is to engage with industry, privacy advocates, and security agencies to address the differences, find common ground, and begin the process of working toward a place where both privacy and security are protected. I call this a process because it will likely take years to navigate through all associated concerns. So what can a person or business do to ensure privacy today in the face of law enforcement pressure? A Supreme Court decision some years ago, before we faced the challenges caused by technology, seems to address the password issue. No person under the protection of the Fifth Amendment can be forced to provide a safe combination residing only in her mind. This would seem to be the same thing as providing an encryption password. This is why in most situations where a person claims Fifth Amendment protection, law enforcement must find another way in. If tech companies are forced to provide backdoors for law enforcement, it seems agencies like the FBI could bypass the Fifth Amendment and gain access to encrypted evidence. To me, this sounds like an end run around the Constitution, but only the courts can decide this. As I said earlier, it would seem that the combination ruling would apply to passwords, but there have been situations in which judges have taken a different view. According to a 2014 article in the Berkeley Technology Law Review, Sarah Wilson contends that the Fourth Amendment, which is protection against unlawful search and seizure, and the Fifth Amendment do not adequately address the privacy versus security issues technology has provided. It will be Congress, the courts, and hopefully the citizens who must work together to bring the Constitution into the 21st century. So where are we and where are we going? Well, the Fourth and Fifth Amendments, written in the 18th century, are insufficient when trying to decide how to manage encryption during investigations. No clear law exists to force tech companies to bypass the Constitution when the Fifth Amendment is invoked. In the San Bernardino case, this was not an issue, but the FBI continues to try to force bypassing encryption in other cases. Congress cannot simply jump on this without involving the people, law enforcement, and tech companies. This is a complex issue that cannot be solved by Congress alone. I agree with Secretary Carter's position on this. Bringing all interested parties together to oversee the process of managing privacy and security differences is the best way to determine the reasonable and appropriate path through the next decade. But while all this sounds good, the probability is very high that this will eventually end up before the Supreme Court. Well, that's it for today. Please visit my site, v-cso.com, for training services and other services provided by our virtual security officer programs. And be careful what you click.